testimony on H410. Just by a little way of background for you, well, we have the Defender General testify next, but by way of background, the version that you're looking at, the H410, is going to probably be fairly significantly changed. I mean, so I apologize for that. We're getting concepts, but we certainly want your comments. I shouldn't say significant. There are parts of this that are going to stay. The significant changes, it's not going to be like DOC, you're going to be doing this on an annual basis. We need to figure out another entity that can actually produce the information we want. Definitely want to, we definitely want to have your input on the definition of recidivism and this concept of class 1 through 4 recidivism in the body, because that is continuing. But I'm only mainly saying it because some of the language is not clear, and we're already working to clarify some of the language. Okay. But over to you.
Yeah. Well, I'm Matt Valerio. I'm the Defender General. I read it. I understand what the words say. Over many years, Vermont's definition of recidivism has never really matched like the federal definition of recidivism or recidivism in other states. I really couldn't tell you why. The only thing that I could surmise, and this discussion has come up any number of times in the 25 years I've been in this job, is that Vermont apparently would want to count things differently than other people want to count for some reason. And that's what I don't know why, but it is different. And I know to these folks in the crime research group who are here in the room, that's really kind of annoying to them when they try to compare apples to apples. When, recidivism rates in one state versus another state versus what the feds do versus what we do, nothing really matches up because ours is different. And so if somebody comes in and says, well, the recidivism rate in Hawaii is, 30% lower than the one in Vermont, and then you look and they're not counting the same things, and we can't compare anything to anybody because there's nothing that is, it just doesn't match up. We do this, a lot of this too has to do, when we're comparing like violent crime rates and when we're because what do they count there versus, and misdemeanors are not really even dealt with that much on a federal and other state level. It's the things that we seem to be interested in, other states are not particularly interested in or are not interested in at all. So comparing, you're not ever comparing apples to apples. It's always, apples to Volkswagen buses or something. It's not, you're not even in the fruit category sometimes. So the question, I had a lot of questions about this, like why are we doing this, changing this now as opposed to, leaving what we had? Because, when you start a new counting type situation, anything you did before doesn't matter either. So we can't even compare, what we were doing before to what we're doing going forward. And, unless you're running like two simultaneous calculations of the same thing that would have a different definition. It just makes it hard for policy makers, you folks, and people in my job and DOC and other places to, it takes a track record to kind of understand what's happening when you change the definition of what you're doing. And so the first thing I thought of when I read this was why? What is the intent of why we are doing this? Now, I could infer that, well, we want to decide to count different things than we have ever counted before. And that's perfectly fine as long as you don't want to compare it to what we did for the last 30 years or 50 years or whatever it is, however long it's been there. The second question the next question I had was, well, we'll do this, and how would it be used? Like, what is the point of, having information just to have information is not particularly useful. what would it be used for? And of course, I have to think of things critically about, what nefarious uses could this be put to? And, or, how could this in some way potentially be used contrary to the interests of our clients? When I look at definitions, measures of, and classifications of recidivism, 1, 2, 3, 4. And yes, there are language issues and the like all in there, as you discussed. The analytical side of me would look at it and say, hey, this looks like a backdoor way to do sentencing guidelines. This is the kind of thing that would take away potentially what is like fundamentally like a big thing in Vermont. And I don't know what Judge Zone said or if he said anything yet. But when you start putting people into these classifications, the potential is that it can be used to pigeonhole groups of offenders into classifications that would call for a particular sentence without actually looking at where the defendant is at the particular time. Because statistics tell you a lot of things, but what they tend to tell you is what people who statistically look like this person, what they have done in the past. They don't tell you what this particular person is going to do now or in the future. And, what gave rise to what puts somebody in a classification, that you might see here. I'm just going to give you an example. So you get somebody who comes in and they get charged with a couple of felonies, unlawful mischiefs, or the like. And when the case ends up getting resolved, and then there are a bunch of trailing misdemeanors. When the case ends up getting resolved, the deal is, well, we're going to dismiss the felonies, but we'll admit to 6 misdemeanors and put you on probation for 6 misdemeanors. Well, when you start putting people in these classes of recidivism, you can have offenses that arise over different periods of time that get resolved all at the same time. And the reason you're pleading to 6 or 8 charges is to get rid of felonies, but then they still have something hanging over their head. So you may end up in a higher recidivism category than you would have if you pled to 1 felony. And if this is just for our edification as opposed to some other purpose, as far as like sentencing or programming or release at DOC, like if it's not going to be used for any of that, which I don't trust that it wouldn't be. Wouldn't. Yeah, I mean, I think it would be. I mean, I said it with multiple negatives, which is a typical lawyer thing, and I love it. But it upends the way resolution cases, because there are collateral consequences that go like with felonies that don't go with it, for example. So you make decisions about what your risk management is for a client, while you can still access, if services are an issue, accessing certain services with misdemeanors that you can't access with felonies, your ability to get housing, your ability to get certain jobs that you can't get with felonies that you can't get with misdemeanors, all kinds of decisions that you're weighing. So when I think about this, I think about how can these classifications could potentially be used in a way that impedes the person's ability to become a contributing member of society going forward. When we put people in these boxes that are statistical boxes as opposed to evaluations of the person where they stand at the time they're sentenced. There's a lot of reasons why you go into various sentences, and there's a lot of reasons why you might actually even pick up charges along the way. You know, at the time certain charges were picked up, maybe they were transient or homeless or you know, something like that. Well, and at the time it comes time for sentencing, they no longer are, so their risk of, you know, retail theft or unlawful trespass or that sort of thing is not the same. But they did have 10 charges over a period of the 7 or 8 months that they happened to be unhoused, and now they fit into the box of, you know, recidivism class 3 or 2. But that doesn't really tell you the story about the person. So if these classifications of recidivism are something that might be used to influence or limit the discretion of a judge to sentence the person as they sit, that wouldn't be a good thing. Vermont, over a period of years, with multiple versions of the Sentencing Commission, has always rejected the concept of sentencing guidelines. And so when we dump people into buckets of classification, which is exactly what sentencing guidelines does, that is a policy decision that and I'm not saying pretty much, as far as I can tell, and the folks, some of these, I mean, I guess there's a couple of us who are on that commission, we unanimously have, the professionals who work in this area and the legislature too, has rejected the concept of sentencing guidelines for our state repeatedly over the 25 years that I've been involved. And so I'd hate to open that door. And if that door does get open, I'll be trying to kick it shut as hard as I can. And I think that you'll probably find the judiciary would feel the same way unless they decide not to feel anyway, which they do sometimes when, you know, there might be a disagreement. But even prosecutors have never supported that concept. It may not have been intended in any way, shape, or form, but it smacks of the kind of thing that's a precursor to that. And I'm always wary whenever this kind of thing comes up, when you're putting people into buckets of you know, buckets of bad, I guess, as I would say. I'm wary of that. I'm also wary of the way the Department of Corrections and perhaps the parole board and anybody else who would have decision-making authority post-adjudication on the release of people, what information is available to them to make decisions about release and what they do. This is another one of those kind of things that I think could be used negatively to individuals who are not being looked at as individuals, but as individuals who fit in a bucket that we have now defined in statute. So those are like the general concerns or ideas that I've looked at. I think that Vermont could use a reworking of the definition of recidivism that brings us more in line with what other jurisdictions do, so that we can try to compare apples to apples or even apples to oranges. We tend to be kind of an odd outlier just because we kind of think things up. And it's not necessarily bad as long as we're comparing us to us. But if we're trying to see like what works in other places and what doesn't, you know, getting some sort of conformity with what we do on the federal level, what we do in maybe neighboring states that might be akin to ours. You know, what does New Hampshire do? What does Maine do? Massachusetts, around whatever, New England, or states that sort of look like us, even though they're way bigger, North Dakota, South Dakota. I don't really know what their definitions are, but, you know, rural states that have rural criminal issues and that might be a way to look at this. If, my guess is, I don't know, sentencing commission doesn't really, I think it still exists in statute, but it doesn't like do anything anymore. But if you, and I'm going to guess what the sentencing commission would do, but why not? I'm guessing what they would do is think about that in a similar way, only because of the discussions we've had in the past, is that if we want to see kind of what works in other jurisdictions that look like us, then maybe we should try to make our recidivism definitions similar to those places, as opposed to kind of going off on our own. And maybe the better thing, if some of these changes in the definition, the facts are interesting, maybe it's the kind of thing that crime research groups should study these particular things and let us know what is happening in these kind of new areas that we have, Vermont has particular interest in, as opposed to changing a recidivism definition. And by the way, we have this recidivism definition. I've been a lawyer now for approaching 40 years, and I've been 25 years in this job. I haven't used the recidivism definition for anything ever.
We haven't in here either. They say something about that.
So I'm not sure, on the one hand, we're like, yeah, go ahead, change everything. I don't care. It doesn't matter. I've never used any definition we've ever had regarding this. And every now and then, some number pops up and recidivism rate is, 58% or something within 3 years. And, and then you're looking at, what does the effect of drug court? In short amounts of time, the recidivism rate's really low early. And then after 3 years, it looks like everybody else. Well, every now and then that kind of thing is happening, but I can't ever think of any policy that has ever been made or any use that I've ever made of a recidivism rate. So on the one hand, it's like totally benign and that's wonderful. On the other hand, I always have to think of, how it could be used badly, and how it might apply to individuals unfairly, and how it would change the way people think about the collateral consequences of plea agreements. So where in the past, you're looking at, we really don't want to have people have felonies on their record. Well, maybe at some point it might be better to have one felony than it would be to have 8 misdemeanors or something. I used to have a guy who was pretty smart relative to the system. He never did anything terrible, but he was one of these guys who would come to November, and this was back in Rutland in the late 80s, early 90s. And I don't know if any of you folks know that area at that time, but we used to have the old Rutland Mall, and the old Rutland Mall used to be up where now the Home Depot is, over there. And every November, the dude would go into Ames and just walk out with a television set or or a tent or whatever. And then they'd arrest him, and they would charge him with at the time, felony retail theft was $100 or something. And they charge him with that. And nobody really cared about that much. And every year he would get assigned to me, because I had represented him for some number of years. And he's like, the deal. I'm like, yes. Yeah, we'll plead to any misdemeanor, no probation. You just want some time to serve, and then you'll be out in April. Yep. Okay. And we'd go and do that. And he would do it every single year, year after year. And then when he got in his early 40s, he got off heroin and actually married a drug counselor, and they lived their lives. He had health problems and other types of things, but he wasn't doing criminal stuff anymore. But the bottom line is this guy would have had, I don't know, he would have been a level 4+ with a red star or something, because he would do the same thing year after year after year and pick up multiple misdemeanors right around the time when he needed a warm place to sleep between November and April. And he would always do time served. He would do straight sentences to misdemeanors so he could do that and be out in April and, then paint houses. which is what he would do. Even when he was on heroin, painted my house. You know, he didn't show up early in the morning. He'd get there like, 10, whatever. He would also work till like 9:30 at night, perfectly happy sitting up there on a ladder. I was always afraid he was going to fall, but he could manage it well, yes. In any event, these things that happen in the justice system that like don't make sense to normal kind of people who aren't hooked up in this, could have different types of consequences for these people who aren't really, I don't know what to say about it, not really that bad, but they could look that bad as you start classifying. And that's all I'm really talking about.
Yeah, and I would think that we could might be able to get around that in a manner. I mean, that's not the intent at all. It's intent to have a performance measure that actually we could possibly use, unlike what we currently have in statute. And we could put in intent language that's for that use only, that only de-identified information. There's different ways we can try to get at your point. But because the idea isn't that, oh, this guy is a class 4 recidivate, so that's not the intent. Language to avoid.
Do you mind telling me what are you trying to do?
What we were trying to do?
What are you trying to do with that?
Well, we're trying to get rid of the old one, which is useless. We could even keep it there and just not call it recidivism. So if they can bang out this report without costing any money at all, then we could keep it. And we do, there are questions well, stepping back, it's because others wanted us to do this, so we thought we'd take a look at it. And when I saw it, it's like, yeah, if we can get this right as a performance measure that we can use, then yeah, that's what my goal is. That over time, we can use it to test how well we're doing. And we can test historically and relative to, like other New England states or whoever. So that I think is, at least that's mine.
Right. I would, I do think there's some value in looking at our recidivism definition. I think that the closer we can get it to comparable would be best.
Yeah, I think.
I guess my suggestion would be to get rid of the buckets, because you can still look at the same information without classifying somebody.
Right.
And you can, take the identifiers off of them and all those kinds of things. But, I would not want DOC to go in and say, hey, here's this definition in statute. We're going to create a policy, regarding, we're dealing with some of this stuff right now about like their risk measures on release that we're actually litigating. And I don't think that they are legally doing what they're doing regarding the release of some offenders. And we have multiple lawsuits pending right now, but that'll work its way out at some point. I just would want to give many more, fodder, so to speak.
Right.
Another, list or class that, it's part of, I'd love to have, we have all these, we have the listed crimes, and then we have the designated crimes, and then we have the super special designated crimes. It'd be lovely to actually, there was a reason why we did those things at one point, and then they grew into something else.
Right.
It'd be great to like shrink those down into a meaningful thing and tighten up this definition into a meaningful thing. And then, kind of preserve our ability to make decisions individually as judges on, sentencing people as opposed to people who fit in a category.
Right.
So.
Questions on that?
thank you.
Thank you very much. This is helpful. I appreciate it. And we'll try to reach out to get the other witness sometime next week on the H5.
Yeah, and I've been talking to her, like we've been coordinating, so if you can't get Camille, just keep copying me if you copy me and Camille between the two of us. It's Camille's fine for everybody in like central office, but when I'm pulling somebody in from the field, she's probably not, she has to be on it because she deals with the calendar, but I probably have to be involved in that. So it's the easy thing is just copy me with everything, and I'll figure out what I don't need to look at. Thank you.
All right, thank you very much.
Thank you.
Let's hear from Kim next, and then we will see what kind of time we've got.
And I sit for a little bit.
Well, remind me why we want this, by the way, after you introduce yourself. Sorry.
Excuse me. Hello, everyone again. Kim McManus, Department of State's Attorneys and Sheriffs. My comments are going to be very brief, mostly because I need to be in another room at 2:00. And because I was listening to the earlier testimony and know that there's plenty of rewriting that's going to be done. So I'm not going to go through, dotting every I right now. Why do we want this? We did bring this up last year. Our department brought it up as something that we wanted to fix. And our primary fix that we want is changing the definition of recidivism. The other sections, as far as classifications, I believe we were sort of being overachieving little students, thinking of these magical future reports that would have these lovely charts and how everything would fit together. And wouldn't we like to all have, these definitions that we all agree on, and that's what would be in those charts, right? So we're thinking ahead to the what if, when we can get there. We are not tied to those classifications, that we do not want anything past the definition to slow us down on changing the definition of recidivism. And it's for the reasons that have already been articulated, that the current only definition of recidivism we have on our books doesn't reflect, I believe, how most of us are using the term, whether we're talking with colleagues or talking with members of the public. And there's just a disconnect there. And we would like to just all be on the same page with that definition, so that when we're using it, when we're seeing it in reports, that's what we're tied to. And understandably, I know those who write those reports will more than likely say, and yet we may change that definition depending on what you're asking us to do the report, and that's fine. But it's noted that it's a change versus all of us using a slightly different definition. As far as what that definition should be, we suggested tracking from conviction to conviction, and then because the conviction then is a known set point, and that you can then go back to the offense date to track, when the person committed the offense again. You may recall Lynn Whelan-Worst testified last spring, and she had mentioned in her testimony, like, yes, we're in the middle, right? We're not going from arrest to arrest. We could go further out as far as how we're defining it, but we're kind of hitting a middle. Sweet spot's not the right word, because nobody's going to be happy with whatever definition we get to, but we're hitting the middle. And basically what we're suggesting right now is as good as any other definition from her point of view, looking at how others also define this. The practical fixes, as far as before we get bogged down with the definition of recidivism, if even at just a basic level, we change the name under DOC of what they're collecting. And this was, we suggested last spring, if you're calling that reincarceration, like that, when you go onto their website and you check their dashboard, right now it says interactive recidivism dashboard. And so again, members of the public are taking that as what maybe they're thinking recidivism is. So just simply at basic level, changing the word recidivism in the definition in 28 VSA 4 to reincarceration would be step one. And then if you were so inclined and thought it was of value to you all, changing the recidivism, having a definition of recidivism, again, that better reflects how we're all talking about it. Big picture, our hope from our department would be that, yes, we're able to use this to see what is working, what isn't working, where are we having success, where are we not, as changes are made to criminal law, procedure, programming, all of the above. That's our simple, and we are open to being helpful in whatever way as you come up with language and want to run language by us. We'd be happy to be part of that process, of course.
Great, appreciate that. Questions? We can. No questions. All right. People.
Nobody wants to talk.
Yeah, I was just gonna say, really things in and people,
And to be continued.
and
Exciting. Excellent.
So Robin, yeah.
please, go ahead.
I'm just taking in, and then we're gonna have a whole nother birthday. So.
The piston problem.
A piston problem.
Yes.
Yeah, I wanna know.
You'll find out. Oh, you yesterday? Okay, good to see you too. Good to see you, Kim.
Anyway,
Thanks a lot.
Okay,
Hi.
hi, it's our turn.
Yeah, it's your turn. So can I ask you a couple questions to kind of guide? I know you have a lot of things.
Do you want us to introduce ourselves first?
Yes, please.
Yeah, I mean, I'm just following the rules.
Yeah, well, thank you. I've been told about how I've neglected to stay on task and rules.
Okay, yes, yes.
And I take that input to hopefully improve myself.
Hi, everyone. Nice to see you. I'm Monica Weber. I'm the Executive Director of the Crime Research Group.
And I'm Dr. Robin Joy, and I'm the Director of Research for Crime.
Okay, so, I mean, I could have you just comment on everything that was already happening, but.
Well, we had some comments that we were still just gonna go with, but you can ask whatever you'd like to do.
Well, I mean, so since I have you here, I mean, so I think we should I like the idea of relabeling what DOC is providing, not necessarily just getting rid of it. Put that aside. Maybe I'll have you comment on that in a minute. And then having recidivism definitions that can be generally used. And then the question to me is, all right, what am I doing with that? Am I asking you for an annual recidivism report? And is there such a thing? And I suppose there is. And understanding that there's a lot of leeway for specific ad hoc reporting. Like if we want to know how many arrests are happening for retail theft and arrests. But having this like one, not the category, I'm a little, I also want you to comment on how important having these classes or categories, or can we get away with like one short definition?
Let me.
Anyway, that's a lot, but those are
Let me
some of the
start
things.
with the, I'm gonna start with the generalized population. Conversation.
Well,
Okay,
the
yeah,
history too.
the history. All right, so, yeah. So one of the things we wanted to bring to your attention, and I think it was part of some other people's testimony, was, well, why do we actually have this particular measure in statute right now, right? So Act 41 from 2011, it was sort of a culminating act from the first round of justice reinvestment. So if you actually look at that act, I think actually the title of it even says like the war on recidivism. And it actually has a lot of some of the initial first round of justice reinvestment changes that happened. Defender Valerio probably remembers a lot of those, but that's when some of the multiple furloughs came about. Anyway, we don't need to get into that history. And then there was this brief section 4 where this definition of recidivism was added. And the reason that was added was because the late Senator Sears in all of his conversations with the Council of State Governments really wanted to be able to compare Vermont to, say, Arizona. And I think Arizona was the example that was used. And because of the way our system is structured as a unified correction system, no jail, no prisons, and the way our sentences are without having these, 1-year felonies, which is the way most states would be doing it, we came up with this definition so that we could compare ourselves to other states.
Or at least Arizona.
Or at least Arizona. I don't know what Arizona's definition or methodology right now is, how they calculate recidivism. And I will say, it is going to be different across every state. So the idea of comparing across states is going to be really challenging.
And one of the reasons why it's different across every state is because different states have access to and different quality data. So for example, Massachusetts, they've got great arrest data. They've got lousy conviction data. So Massachusetts on their rap sheets, especially those that get right. See, yes. So they arrest everybody. They don't try or convict anyone according to their rap sheets, which isn't true. It's just the way that the record systems are developed. And so that's why they don't use their Corey data. We use convictions because we have excellent conviction data, but we don't have good arrest data because we don't fingerprint a lot of people who are arrested. We'd have to use a different system. We'd have to add a different system. So a lot of times the definition of recidivism is based on convenience of the data that are available. And that is true when you're a researcher, and it's true when you're a policymaker. These are the data that are available that we can make this decision on, or we can create this definition on. And the definition that you're currently operating under with the Department of Corrections can calculate that all within their own system.
They don't need anybody else.
They don't need anyone else's data, right? It's a definition of convenience. And they would need to add other data, or the Statistical Analysis Center, who's currently us, would have to do it with the criminal histories to get a better definition. So that's one of the things I want to make really clear, is that the definitions of recidivism in studies that you read, that advocates bring in and say, oh, look, the recidivism rate in drug court, for example, is this. Well, they only looked at the town that the person lived in, right? So you got to dig down.
So that's a little bit of the street, and the Department of Corrections has been able to calculate it independently since that definition went into effect in 2011. It had a small change in 2013. But when we think about that definition, which we admit is very limited, right? It's only people who are sentenced to 1 year, right? It doesn't include anyone who might be on community supervision. That's something that's pondered in the new bill. But it misses a lot of people who have short-term sentences. Technically, it would have missed the person that the defender was talking about, because that person was only probably sentenced for 6 months, right, Matt? Yeah. So, all right. So they wouldn't have been included. But just sort of going back a little high level, this generalized recidivism measure, whether or not it's the one we currently have and the ones that are being entertained in this bill, is not a performance measure. And this is a term that I've heard a lot of people say today. It is not a performance measure. It is a population indicator. So it just tells you sort of long-term what is happening generally about the criminal justice system. It does not tell you, for instance, that you put a policy in effect 2 years ago, and then 2 years later you see a change, and you know that this is the reason there may or may not be a change in the recidivism rate. It will never give you that answer. That requires a specific type of research study, and then a different calculation on the recidivism rate based on that particular study. So as an example, I've got a couple of them. Of course, one that you're all familiar with is our diversion study from 2019. There's a recidivism rate calculated in that study. Shows that diversion is very successful for first-time offenders. We also did one for the Department of Corrections Risk Intervention Services, right? We gathered very specific information about that program about what that program is doing, about the activities, about the people who are engaged in that program, and calculated a recidivism rate. By the way, it's a very effective program. You could read that report online. So a generalized recidivism rate, and and I feel like I'm bursting bubbles here. It's not going to tell you whether or not a specific program or policy is actually making a difference.
So what will it tell us? Why do I want a report that does recidivism in this new
Because
definition?
it can give you an overall sense of the criminal justice system. It just doesn't tell you why and which factors may be contributing to that rate. So it's sort of like and that's why it's called an indicator. It indicates something. You need to start going and looking a little bit more deeply into what's bringing, what's being involved in that indicator.
Yeah, so
Yeah.
one example in the Act 40 report where we did do a recidivism rate of the furloughees and returns on furlough after justice reinvestment. So that's one of the websites that we created for you guys. The reason why your recidivism rate went down is because you changed the policy. That's really clear. We can show it, right? It didn't, right? And what you changed is that you can't bring people back in for certain violations, right? And so you can see that in the data. So that one you can see. But it's very specific. If that was rolled up to the general population, you wouldn't see it. Like, right? So we have to kind of.
So let me ask you, if we have this definition of conviction to conviction.
Right.
We have that definition in here. We don't ask even necessarily for an annual report. Maybe we do, but we say, okay, we want to know how our furlough changes have done. And what you do is you do a recidivism of, you do a study of what the recidivism rate was before and then after the policy. But we at least know that that's the definition that's being used.
Yeah.
Or for any number of policies that we might pass. And you can look back in history to get a recidivism rate from prior times before we have the policy, right? That's this is an ad hoc type report.
Okay.
And then after we've given it 3-4 years, like pre-charge.
Yeah.
Except I don't know that would.
No.
You want
That doesn't work. My conviction versus, that's a good example that we would ask you for an ad hoc report. But we have the definition, we have the definition and then we compare how that definition looked before and after. But at least we have this consistent definition for those specific asks that we have, whether we do an annual report or not, which is the second question.
Yeah, I mean, I think if it makes it easier for folks to digest the data, that is, it's one less footnote you have to read, right? When I do the reports on recidivism for other projects, right now, I always include the statutory definition, and it's always 0 because generally that's what it's right. Because nobody in diversion is eligible to be in that, it's just not a good definition. So that's always 0. So I always do that. I do it because Senator Sears would yell at me if I didn't. And so I did it. And then I would do what I wanted to do. And sometimes, usually it's a 1 year, 3 year, or 5 year. It depends on the quality of the data going back or something. So if you want something, so there's one less footnote for you to read, that's my definition of recidivism, then yes.
Well, just be one less footnote, but just a kind of a general understanding.
Yeah, it would be a
unless we hear differently.
in this body. Yes, in this body.
Right.
Yes, in this body. But when the Defender General or the state's attorneys comes with you about a study that was done elsewhere, it's incumbent upon you guys to ask those questions. What is that definition? And can we know who is the population and what, I remember years ago, when drug court was just kind of starting and Matt said, what do you think about these studies? And my snarky answer was, well, when we get public transportation and a meth problem, it'll work really well. And thankfully we never got the meth problem to the extent that some of these other places did. We still don't have the public transportation. Right. And so, but that's one of the things that impacts, attendance at these specialized courts that have a lot of requirements for folks to come in. So yes, I think that having a definition that you then all internalize and that you go forward with and that you agree with is helpful. I think, the details, I on the violence stuff, and this gets to the details a little bit, I would actually just say, because I think about what you're going to ask me when I come in and do a recidivism, right? And so, sorry. I give you let's say you decide the violence issue and I say, okay, the violence recidivism rate was 44%. And then someone here is going to ask me, well, what is it for domestic violence offenders? Right? And I'm going to say, well, that's not what you asked me to calculate. I'm going to have to go back and we're going to have to redo all the math, which isn't unsubstantial, to answer that question. So you're going to ask me about domestic violence recidivism rates. So put the domestic violence statutes in the bill. Like that's the one that you want. If you know you're going to ask me about sex offender, about rape and sexual assault, put those specific statutes in the bill. I would add DUI because that's a really common.
What statutes in the bill? Put
The
the,
statutes that cover the reference to this, to the statutes on sexual assault. So the 325, I forget what they are,
I
but
mean, if we were gonna put in for reports here,
Yes.
you mean, or if we ask you for a report in the future.
If you're gonna do a
we would
general-
say, go to our recidivism definition for the report. Or you'll provide, I mean, that will be the presumption and then
Yes.
maybe.
right. So if
Different.
you don't do anything specific in this bill other than define recidivism, right? And then you leave everything else to ad hoc reports, that's fine. If you were going to put this violence category in there, I'm suggesting don't and just do the specific.
No, we're not right, that'll take too much.
Okay.
I think let's take a smaller step.
Okay.
Just being the recidivism part.
Okay, fair
Okay.
enough, yeah.
So, all right. Yes. So, okay. So just looking at the recidivism, yes, absolutely a definition, working on a better definition that encompasses what is the business of the criminal justice system in Vermont is important. And the business of the criminal justice system in Vermont is misdemeanors who mostly don't get sentenced to a year in prison. And so figuring out what that should be, and we can help you with the details on, you want to use the incident date as the next date, as the date of when the person offended, like that's where you do the calculations, and I can show you how those calculations can be done. To the Defender General's point on how are these data going to be used, traditionally, no one's used this data. It's never shown up in anyone's, rap sheet,
The
and
Department of Corrections at this point
Does not.
Does not take that cohort of people and then, put it on a record somewhere and said, this person was a recidivist in 2018,
right.
and I don't think the statute envisions that either, but,
But, yeah. Or if the Statistical Analysis
Yeah.
Center does it, then the Statistical Analysis Center does not have any overview over any
Yeah.
humans in the system.
On the other hand, I do think, taking out if you wanted these sort of, yearly breakdowns, you could still keep in there, well, we want rates at 1, 3, 5, and 10 years.
Yes.
You just don't need to call them classes of recidivism.
Right.
Right.
Yeah, I mean, we can even keep it as simple as we're measuring conviction to conviction and we're determining the subsequent conviction on the arraignment date, period.
Yeah.
And when we're asking, if we decide that there's a valuable annual report, and I'm not convinced that there is, but at this point, then we can decide how long. And then for any ad hoc report, we know at least it's going to be conviction to conviction with arraignment as the date for the subsequent conviction. And we can say we want 3, 5, 10 years. I mean, we do it that way.
Right.
And so, but I think, so one of the big questions and this is kind of where I'm scared, and I'm going to try to have this as our next version for us to comment on. But I do want to understand from the committee and from stakeholders and such, is there an annual report that could be of value for us that is worth having you do? And I don't know if that's if you're able to answer that, or.
It's always the question of what, I mean.
To Counselor Johnson's point earlier today, I think that there is a value, maybe not for you necessarily, but for the people of Vermont to see their experiences reflected in the data that is produced by the government. And so there's that,
So just a general recidivism rate for the whole population, whatever.
Well, so I would add a few things to that. I mean, just if I get to just play,
Please,
right?
please.
So the recidivism rate is something that people feel strongly about. I think right now, in this time that we're in, people also feel strongly about how many people are committing new offenses whilst out on bail. Right? That's not going to be covered by that recidivism rate, but you want to know, and here's something where you are effectively trying to do some policy work. where you would want to see that number kind of go down a little bit, or maybe you would see it go down in Chittenden County where you've piloted enough that you could say, now we need a real study because we're seeing some anomalies here that we want to explore a little bit more. So there's that. There would also be, I was thinking, some states do reports on how many first-time felons are getting prison sentences. How many first-time offenders are getting prison sentences? How many first-time offenders are going to diversion? How many people going through the system have a criminal history, and what does that sort of stuff do? I mean, you may be waiting for a minute, so. Wait.
But these are also types of things that used to be reported.
You should be reported, yeah.
So you went past recidivism.
I did.
Recidivism.
Yeah.
No, that's just good. I don't know if this is the bill
The
we
bill
have.
said other measures, so I'm just
It
throwing
did
them out
say-
there.
Did I say other measures?
No,
It's in the title,
yeah,
Oh,
yeah, I mean, no, it's not, but
So, sort of.
yeah, well, I mean, we can. Are those just one-time reports, or are these reports that have in the past been done?
so the Department of you might remember, some of you will remember, a document called Facts and Figures that the Department
Yes.
of Corrections would publish every year. And in that report, it did have, first-time offenders. It was 200 pages of charts and graphs of things. And it was well beyond actually the data that the Department of Corrections was responsible for reporting at the time, which is why, now, I think they pulled back, which makes sense, right? They shouldn't be reporting on the activities of the court, but that was all in there. But some of those things were they were in that, and then there were other things around juvenile justice
Yeah,
and
we used to
DWI.
publish, we used to publish an annual book on juvenile justice, and we used to publish an annual book on DUIs and on crashes as well, separate from DUIs, because DUIs are still one of our most common crimes in the state. How does our policy look around that? So it depends on. It's one of those things where I think that people used it and then sometimes they didn't, or they forgot about it,
So
But I think
what we
they-
normally do now is I think we try to sunset the reports.
Yeah.
right.
So we would have to look at it again.
But that wasn't to the legislature, that was just EOC.
It was a published report that they did, and it usually came out, at the very beginning of the session, and
Right.
it was a tool that they used during the testimony. And I think the important thing there was that there were recidivism measures in there, but there were all of these other measures as well that provided context. And I think that the recidivism measure on its own, like I said, it's an indicator. And what is the context that you want around it? I think that's a question for.
So let me just,
Yeah.
so I'm not hearing that there's a recidivism report based on whatever definition we have that would necessarily be valued. A good use of whatever resources we can possibly muster for.
It's valuable in that if there's change there, it gives you that sign and you know it.
So why don't I'm gonna throw this out, we're gonna have more discussion tomorrow on this, but that we're gonna move this to Title 13 somewhere. It's gonna be the criminal justice data reporting. We're gonna get rid of this DOE, or we'll rename the DOE definition, DOC definition. And we'll have this new definition there. We will decide among ourselves, like, what are some reports we want to start for like a 3 to 5 year period. And then we'll see if we can find the funding for that, unless that's also included in what you already have in the VPS.
It's not included in the current contract we have.
Or maybe we can find out how much money we can get. We can say, how much can we get for $100,000? Just wording on the name.
You can get a lot for that. You could get a lot for that. Yeah. You could get a lot for
Just taxpayer dollars.
that. Yeah.
Taxpayers want to know.
Right.
They want to know what the hell's going on and if we're making any difference.
And it is a very legitimate use of a statistical analysis center, and this is what statistical analysis centers do.
I mean, we can also put this in here and we can say, these are the reports we need to be able to tell to our, to the Vermonters and to guide our own policy making and such. And it will all, of course, be subject to whether there's funding, and we understand.
Right.
I ask a question that is about this if we're gonna get to play a little bit and think about like
Well, yeah, we
reports and
should.
things that would be helpful. I really appreciated the question that Barbara asked earlier and the point that you just raised about why recidivism generally is not a performance measurement. Whose responsibility is it to request the types of reports that would help inform policy decision making?
Yes,
Just making sure.
yeah, or it could be the executive, it could be DPS. it
Well,
could
that's
be-
what
yeah,
I'm
yeah, it could be-
getting
yeah,
at, that like,
yeah.
are the services of
Well, the other
physical
thing is that
analysis
some-
are available to?
Yes, so for
the executive
instance,
branch, for instance.
if they are interested, of course. I mean, in some ways, you know, the Department of Public Safety, of course, is by executive order, the Statistical Analysis Center, and by contract, we provide that service. Okay, so the SAC is an arm of state government, right? It just happens to be a contracted service. And the contract that we have, you know, envisions a certain body of work, but it doesn't need to stay that way, and it can be expanded. And arguably, I would say it should be expanded. That and related to your other question, there are often times when people who are organizations who are implementing a program on their own, they have a grant, they build an evaluation money in that grant, will hire us as the nonprofit entity that we are, right? So that they can get those kind of studies as well. So they're all interested themselves in the impact of their programs. It just depends on whether or not they've got that.
Yeah, and so, I mean, the Department of Public Safety is growing a so-called data lake. They may be doing reports themselves. We should find that out, and we should find out which ones we're going to direct DPS to give us.
Right.
And the same goes for, you know, the Attorney General's Office on Restorative Justice. We're going to be getting that data, but there's stuff. So I like the idea, because it's all over the place, of maybe having one place in Title 13 that is kind of criminal justice data, and we'll take care of this thing here, and we'll start building up
The Vermont data portal.
the Vermont.
I'm just thinking, I'm just
I mean,
thinking
it's-
about the legislature's relative inability to be particularly responsive and agile. And that,
As one of the more agile state legislatures.
I'm sure we are.
But still, having
But
said that.
still, having said that-
Except
I just want to understand clearly. I want to make sure I'm understanding correctly. That there is this other entity that works 365 days a year, that is the executive branch, that has the same ability in many ways to request the types of information that we're now spending time brainstorming, without the added benefit of working in the jobs that would benefit from this information. And we're hearing from the executive branch that we need to write this, to pass this bill, to change a definition, to provide a performance measurement that isn't going to provide that performance measurement. All the while, they could do the thing that we're now here spending our time trying to do without all of the information that they have. So I just want to make sure
Yeah.
I'm understanding that correctly.
The only thing I just will correct, because Jay Johnson's testimony went beyond like this kind of standard. She was talking about arrest rates I mean, she was going further to stuff that might actually tell you something.
Into the context, performance
Right.
measures.
Yeah, she like,
Area,
yeah, it was like, she was getting away from just this like one report on this recidivism
Right.
thing that we have here,
Right.
to actually where she could answer some questions.
But as Barbara mentioned, it's still a very high level, data set, and it's not
Right.
telling you, here's the thing you did that actually.
Recidivism,
Yeah.
right, no,
Right,
it
recidivism.
will not.
So it's not
Yeah.
taking into account the things that we take into account in evaluations, but we take into account criminal histories. We have a way to score what that person's background was. How much, therapy did they get?
Yeah.
Right? The drug court databases that they use are fantastic. That gives me the risks, the drugs that they used, how often they use them. They get all sorts of stuff. So then we can tell you, here are the people that drug court's really good for. Here are the people that aren't being served by this. And then you go back and you change, why. So there's a lot that goes into program evaluation on what program is working and what program isn't working. The recidivism as a general, 44%, I'm making it up, 44% is around there, reoffend within a year. That just tells you that, or 3 years, that just tells you that there's a lot of people that something isn't right.
Something isn't working. We don't know what
We don't know what it is.
We don't know.
Right. There's a circle, and we don't know what it is. You're right. And so
Then
yes.
it can be anything you want it
So-
to be.
Well, right.
Can I-
Yeah.
Yeah, just on your point, so yes, it can be frustrating that the administration, that the state government that's there all year round, and it's not even partisan, it's not even just the current governor, but the past, that they have the access to this data. And they may be using a lot of it, and are they providing it to us? Sometimes when we ask the specific questions, but so I think, yeah, that part's true, but I'm putting that aside. Let's figure out what reports would really be valuable for some of the things that we're trying to track or anticipate tracking the next 4 or 5 years. But Ian wanted to weigh in.
I just wanted to clarify two things. So first, I really
This, by the way, seems like discussion, but that's okay. We're with our data friends.
yes, and that's why I'm going to start this little discussion.
Okay with that.
So I
We're
really
okay with
appreciate the direction this is going. I think moving away from felonies or violent crimes or felony violent crimes, something like that, or a year or more, or anything like that, is not going to capture like the vast majority of what's going on. And so moving away from that and just going to like recidivism generally, I think is the move. And that makes a lot more sense to me. My one question is, in your example around VCR, violations of conditions of release, I want to make sure I understand. I would assume that would be captured in the recidivism data.
No, so it's if you, not necessarily, because really, one of the things that we know is that a lot of those VCRs.
It's dismissed as part of the
Dismissed,
resolution.
right?
Okay. Yeah.
And so, we do have a nice report that I finished last year on VCRs,
Yeah.
and how many of those are attached to another new offense, right?
Yeah.
Because that was one of the things I had to look at was
Yeah.
what's just, not a new offense and what was they didn't update their data or,
Yeah.
whatever. So we do have a report on that, but yeah, I mean, but people are interested in,
Yeah.
and I think that especially on the VCR discussion out in the public, they hear the VCR, they assume that a crime has been committed or something along those lines, and that may not be the case. And that's where you have to kind of dig into
Yeah.
what else was happening,
Yeah.
what else got filed.
So if there was a plea agreement where the underlying conviction was their underlying charge was a conviction, and they attached on a couple of VCRs, then
It depends
That
on
would
those
be-
dates, right? And I can show you how that works.
Yeah.
But, so for example, on those global plea agreements that y'all like to do, if Chittenden disposes of the case, at a different time than Windsor does, I have to like do the math, like I usually do 30
Uh-huh.
days. Did it get disposed of within 30 days? And I think that maybe it's all part of a plea agreement that y'all agree to. But sometimes I've seen global plea agreements where the next court date and then the other county is in front of a month and a half, and I miss it.
okay.
And the thing
So
about
there's a lot of weeds.
Yeah, I'm just trying to
Yeah.
yeah.
the thing
Yeah.
about the
A
way.
lot of this is all happening within the same year.
Right.
Yeah.
I
So
think the way it's calculated now, right, is you get a cohort of people who have been released in the year of study, right? So 2025, who was released during that year, right? And then the Department of Corrections will follow those people for 3 years. And the first time that person meets the criteria, it doesn't matter why, it doesn't matter for what crime, it doesn't matter. It's like you have met the criteria, which is you have now been returned to incarceration and you were there for 90 days or more. That's all that's looked at, right?
Mhm.
So those types of things are not part of the, you as a researcher, sure, you could go in and do that, but
So.
You don't need all that detail to actually calculate the
Calculate
rate.
it.
And so if we want to,
Yeah.
like you guys did
Yeah.
last year, you want a more specific query about things like that. Okay, that makes sense. And my only other question, more to Matt's point, was like using this for other things. So can you explain to me how you wouldn't see something like habitual offender enhancement, but somebody just goes like, well, why don't we just use the recidivism, like three years? Just
Yeah.
explain it so that I feel
Okay,
better.
Okay.
so, I'm going to talk from my perspective, and what we do at the Statistical Analysis Center,
Yeah.
and then a little bit from DOC's perspective. From my perspective, I answer to the Institutional Review Board. I don't survive a subpoena. If you were to subpoena me for research records, I generally don't survive one. I would have to turn over my research records. So in order to avoid that possibility, I have two things. Sometimes I have federal funding and that puts a shield over me. And that means, nope, you cannot subpoena my research records. But just in case that fails for whatever reason, I actually separate all the names and dates of birth and any identifying information. It's all in this other file that I keep only until the results are published. And then I overwrite it with a series of Black Sabbath albums. And then you can, good luck trying to get it out, right?
If
You're curious, right? And so that even if you did subpoena me, that data's gone.
Yeah.
Right? You're not getting that information, and you will never know that 24601, to use John Valjean's number in my study, is actually me. Right? You're not going to know that. So that's how I do it. How I protect the people from any subpoena that might be used. Then, of course, you have all your rules of evidence that are going to say that my data is not the official record of the courts, that I wasn't using, all of those sorts of things. From the DOC's perspective, right, that's a little different.
Yeah.
DOC's perspective, that's a lot of work.
Okay.
To match up this particular person who's already been released and out of their custody, who now is coming back, and it's a difference.
It's just the DOC data and research team does it. They're not, at least as far as when I was there, we wouldn't go and submit. I didn't get the cohort and then get all the people who are recidivists and then spread it around the department and say, okay, here's your recidivist list for this year. Here you go. Because the idea of recidivism is it's just a population level thing. It's not an individually based piece of data.
Yeah. Okay.
Right. So it's not supposed to be applied to a person.
Yeah.
Yeah.
Yes, of course.
Thank you. So back to Angela's point, what if we, and I'm thinking Tom and Martin will remember this, there was a time when we always had to do results-based accountability.
Yeah.
It was like, everything's gonna be results-based, and it was like this.
I remember these days. I used to have it. I mean, and that's sort of where I'm pulling this from, because I
How much you
gave
do.
these presentations.
So amorphous though, but okay.
But it did accomplish, but we now change laws, we start programs, and I think just even like 2 days ago, you were like, how will we know if this is working? So if we built something into some measure, and I guess this is not with existing resources, we're doing bail reform. It has to include a 3-year data set or something.
Yeah, we've been talking about that. Yeah.
But like, if it just, like, I don't know how we
So
keep to it.
So here's my thinking on this. It goes back to, we're gonna have a new chapter in Title 13. This would be our criminal justice data. We're gonna deal with this crap here. And this is gonna be where it doesn't matter if it's bail somewhere else in our statutes. We're gonna have a paragraph there for what we're gonna be collecting. It's like, this is going to be where all the data that we're collecting, whether it's like an ongoing thing, and that's the other thing I'm about to say, but it could also be, all right, we're passing something dealing with this policy. We want to have data associated. We'll have it, maybe we have it in 2 places, or maybe we have a cross-reference to that title, where we're looking for, this is where all the data, because I get lost as far as what we've asked for already. And that's something we could do. But the other thing is, my intentions to do what I just said, but like in 6 weeks or it's not gonna be right away. I want us to kind of get back together and say, well, what are we gonna have as the first data things that we want to have in there? And what I'm gonna ask folks to look at is the Act 14, no, S14 or is it Act 14?
40.
Act 40.
Yeah.
All that data that is already collected, and should what we're trying to get funded going forward be some subset of that continuing data that we already have a start on. I know that you have interest in the time of incarceration, that hasn't been updated in a little while.
Sentencing data.
Sentencing data. And we can look at what we are passing, and just to get kind of just to see that concept that we have in one place. I mean, tell me this is a terrible idea. We have this one place where it's like our criminal justice data collection. And so we'll kind of return after we've all had some chance to kind of think, well, what data going forward will help us? And is there any particular thing we pass? And we'll have like expiration dates or sunset dates on, things that we only need 3 years. But that's been a frustration, is not knowing what data we have, not, having that. So, and if I can ask you to like send us an email, because I think we need a little break before our next testimony of, like, what are some of the types of, because the data that's available.
Yeah.
You started to list, and I cut you off. But I'd love
That's
to
okay.
know
Yeah.
what those are.
Those are, yeah.
And
Yes, I can do that. And then there were just two other things I wanted to say, as you're thinking, to your point on the juveniles. So we do have all that data. We actually have all the names and dates of birth of juveniles who go through the system, in family court. And I do have a contract right now with DCF to do, a recidivism study on 18-year-olds who are in family court, right? The raise the age stuff. I would ask that you guys not do anything until I finish that study and once I get to work with that data. But I do want you to know that data is there, that we've been collecting it. And as a statistical analysis center, we have an MOU with the courts to get that data. So it is there. We can do something with it. It's just, let me work through this process first before you throw anything in that legislation.
And on that, or I guess on that, do you have data, regarding conditions of juvenile probation and?
No, we know that they got probation. We'd have to work with the judiciary to see if they're putting in those conditions like in Odyssey, and whether that's an extractable field. There's a whole lot that goes into that, but not right now.
Okay, thank you.
Thank you very much.
Okay, all right, thank you. Well,
Thank you. Happy New Year.
We'll talk soon.
Nice to be back.
Matt, do you have any final input or comments, or you just hear this? Just chilling.
Well, I have to go to house.
Okay, well.
But I will say, the only thing I will say is that, my conspiracy theories about
Yeah.
what this stuff could be used for was just based on the fact that what was proposed didn't say it couldn't be.
Okay.
You know what I mean?
Yeah.
I got it.
And it didn't say anything about, private identifiers or any of that stuff. So
Yeah.
Understood where
I
you're
know what they're doing now with it, but,
Yeah.
when you change something,
Something, right.
and
I appreciate.
you can't trust everybody. I don't know if you know that.
Yeah, I trust that.